Is the county ready?
Yes, sir.
Okay. Good morning. The time is 9 o'clock. I hereby call the Citrus County Code Compliance hearing for Wednesday, August 19th, 2026 to order. And I actually have two agendas, so I'd like to just ask a question about that. So why are there two agendas for the hearing?
That was going to be a part of the staff update. So we're in two different databases, software, what have you right now. We're finishing up one. We're working our way out of N4 going into Acela. So.
Okay. Well, in that case, it appears that the first page of the agenda is the same. So the reason why I bring that up is first item on each agenda is the call to order. We just did that. The second item on each agenda is the pledge to the flag. So now I'd like to ask you to join me as you are able. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you, everyone.
Good morning.
Good morning.
If any person decides to appeal any decision made by the Code Compliance Special Master with respect to any matter considered at this public hearing, he or she will need to ensure that a verbatim record of the proceedings is made, which record shall include the testimony and evidence upon which the appeal is to be based.
Okay. And then on each agenda, the next item regards the minutes from Wednesday, July 15th, 2026. I have reviewed the minutes. Are there any proposed changes, modifications? To go ahead and approve the minutes. Staff update.
And the staff update, for the two separate agenda packs, the Acela cases, or the other, they will have they're more separated on the pages if
so
that
which
helps.
one, give me an example of a name on the quote Acela agenda.
So that agenda will start with A&M Properties Investment.
Got it. And is it the county's intention to call one set of cases or the other set first, or is it mixing and matching?
It will most likely be mixed and matched, unfortunately, just how our citizens have came in, and we have to, first come, first
Sure.
served.
Okay. Well, I don't think I have a problem with that. Is it going to be sorted by the next, or gradually taper off over time?
Gradually, yes, sir.
I see. As you bring the cases that are under the old system.
Correct.
Okay. I understand. Is there any other staff update?
No, sir.
Okay. I have an update for you, which is that I know I said at the July hearing that I would get an order out on a case. I did not get to it. I will issue it in the next week or so. And do we have another county attorney here, or?
Morning, Your Honor. My name is Val Shilley. I'm the Senior Assistant County Attorney. I'm covering this case for Kim Harrison.
Okay, great. Welcome.
Thank you.
All right, so with the staff update complete, I would like to make a statement. Good morning, everyone. My name is Christian Waugh. I'm a licensed Florida attorney acting as what is called a special master. That's a fancy title created by law, but what it means is that Citrus County has hired me to preside over your hearing today. What I'm going to tell you during this opening statement applies to each of your hearings, so I would appreciate it if you would pay attention. When your case is called, please come forward. You will be placed under oath if you wish to give testimony. If you are appearing at a hearing like this for the first time, the county will call the case, and I will allow the county to present its case. You will have an opportunity to cross-examine any of the county's witnesses, and then you will also have an opportunity to present your case regarding the violation. That will be your opportunity to present evidence and to make legal argument. It is important that you take your time during this process because it is likely going to be your only chance to make your case to me. I will also ask whether or not you are contesting the violation. If you do not contest the violation, I will assume a factual basis for the violation exists and proceed to ask how much time you need to fix the violation or to work with the county. This will help save time for yourself and others, but you are by no means required to do so. In other words, If you think that you can work with the county or willing to admit that there is a violation on the property, I'll give you a time to comply. We'll take your case first and get you out of here. But again, if you want to be heard, that's totally fine. It may also be that the resolution you come to the county is a better resolution that you might get with me, so it's an opportunity for that. In any event, at any time during the hearing, I may have questions of parties, witnesses, or staff. Before issuing a ruling, I will ask if there are any members of the public who wish to speak, and if there are, such members of the public will have an opportunity to speak in your case. Such right to speak is not unlimited, and public comment should be focused on the case and made as briefly as possible. Although persons may be upset or even passionate about what they have to say, all witness testimony should remain civil, and you will not interrupt other witnesses, parties, or attorneys. In most instances, if you are found guilty of a violation, the law requires that you be given a time to comply before the fine begins. That means you have to fix the violation by the date that I give, or the fine will start accruing for each day that you're in violation. The law allows Citrus County to impose that fine as a lien on all of your property. The county then has the right to foreclose on that lien, or to seek money judgment against you after the lien has been recorded for 3 months. I encourage anyone here who has questions about their rights or remedies to seek their own legal counsel. There are some cases that the county will say are of the nature that they're irreversible or irreparable, and therefore they will ask me to assess a fine today, up to $15,000. And that will start immediately if I agree with the county. In all cases in which I find that a violation has occurred, I will impose all costs required by county law. I incorporate this into all of my orders as standard provisions. If you bring your property back into compliance with the code during the time that I allow, that cost will remain minimal. If you do not timely fix the violation, you will be responsible for additional costs, as well as the cost of the lien imposed. You do have the right to appeal any order I make today, as may be provided by law. Thank you.
First case on the day's agenda is Cypress Crossing Professional Park. Case number 2026-644, Code Officer Cody McGuire, page 6 of your agenda, and the N4 packet. Expert on the case, Land Development Director, Joanna Coutu.
Okay.
I do.
I don't think you necessarily have to do that, just for the record, Mr. Hartley. All right, good morning. So I think, is this a case where you've filed a motion to dismiss?
Yes, I filed a motion to dismiss the notice. I was hoping to be able to resolve that issue prior to the hearing, but now that we are here, to the extent that we could be heard on the merits without prejudice to us, I'd like to proceed, but with the caveat that we didn't have the full factual description or any trading of exhibits prior to. But we may be able to at least move the case forward today.
Yeah, I mean, I think first, if you don't mind, I would like to hear. I read the motion. I don't have a copy in front of it. I don't know if you have a copy. Do you have a copy?
Yeah.
Yeah, please. Is this one that I can keep, or do you need it?
Keep that. In there is a copy of the notice of hearing, the relevant portion of the code, some exhibits that I may enter today, but bracketed in there, you'll see the notice of hearing with the exhibits, as well as the portion of the code.
Then in that case, what I will do is I will let the county review it. However, I was hoping, is your motion to dismiss in here?
It is.
Oh,
It
okay.
is.
Let me just see here. I see my pre-hearing
It's
order.
tab C on the right-hand
C,
side.
okay, got it. I think I can, I had a reason why I didn't rule on it before the hearing, so let me just take a look. Motion to dismiss, notice of hearing. Okay. Okay, the reason why I didn't rule on it before is that I was busy. But I
Understood.
wanted you to know that I would look at it, but so I've reviewed a copy of it, and my understanding is that the basis is, okay, Citrus County Code says it needs to provide my client notice of the legal basis and the factual basis, and that the notice is deficient because it really doesn't provide sufficient factual basis. Is that correct?
That's
Okay.
correct.
I think it's an interesting argument. I've never seen it presented here while I've been the special master, but it appears to me that the notice of violation went along with it, and it does say, please remove dental sign. So is that?
Yeah, that would be the remedy, but it doesn't state the factual basis for what the actual violation is.
Okay. I'll deny the motion because I think that's pretty sufficient for identifying the factual basis. So I want to handle that before I even hear the county, because I think if I dismiss it, I don't need to hear from anybody. I'm not dismissing it. Now, what's the county's case?
Cody McGuire, Citrus County Code Compliance Officer, case number 2600644, Land Development Code, Section 9290 billboards. The address is 7052 West Gulf Lake Highway, Chris River, Florida, and the property owner is Cypress Crossings Professional Park. Good service via signed certified mail return receipt, and I'd like to authenticate the following documents and request that it be admitted into evidence. Exhibit A is photos taken during an initial inspection on April 29th, 26th, photos taken during a corrective action inspection on June 26th, and photos of my final inspection on August 18th of 2026. Exhibit B is a copy of the notice of violation, copy of the notice of hearing, copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
If you don't mind, if you could speak a little slower just so I can take notes.
Yes, sir.
Could you give me a factual narrative about what the county's case is here?
Yes, sir. So the county's case here is the billboard's not supposed to be there.
Okay. You're saying there is a billboard on the property,
Yes, sir.
and you're saying that the county code does not allow that billboard to be there.
Correct.
Is there only one billboard?
Yes, sir.
Okay. I'd like to ask, I don't know if you've provided this to Mr. Hartley yet or not, but can you show Mr. Hartley your proposed exhibits?
Yes,
And
sir.
of course, I welcome any commentary, objections, et cetera.
No objection.
Okay. Then without objection, I'll just take a look at exhibits A and B as evidence. If you don't mind, Mr. McGuire, let me just take a quick look here
Yes, sir.
so I understand what's going on. Okay, good-looking sign. Go ahead.
All right. This property is 1.065 acres and is zone G, or general commercial. And then on April 29th, I conducted an initial inspection and observed the billboard in question. I conducted more research with land and development and learned that the sign was not permitted. On June 26th, I did a corrective action inspection and realized that the sign was still there. I've also spoken to representatives from the services throughout the whole process during all this. And then as of my final inspection on August 18th, the sign still remains erected.
Okay. So you had a complaint about the sign?
Yes, sir.
And in your conversations with the respondent and/or respondent's representatives, what was the nature of your conversation?
Basically, the reason why I was there, telling them about the billboard, the research that I conducted previously to let them know that it was in violation. I explained that they were going to be receiving mail, everything through. They said that they were going to have Mr. Morey be in contact with us, and which he has.
Okay. Fair enough. Mr. Hartley?
Yes, if I could just ask
Yeah.
a few questions. Do you know when this billboard was erected?
I don't know when it was erected.
All right. Do you know what the relevant law concerning billboards was in 1973?
No, I did not.
Okay. Do you have any evidence that the billboard wasn't erected pursuant to the law at the time that the billboard was erected?
No, sir.
Assuming that it was lawfully erected under the law at the time it was erected, is there any evidence that the billboard has been modified in a way that would make it become an illegal, non-conforming billboard?
I guess I don't understand it fully.
So pursuant to the code, there are prohibited changes for billboards that are erected legally that are non-conforming under the existing code. Under those prohibited changes, do you have any reason to believe that any of those actions were taken?
You're talking like maintenance-wise or keeping up
Correct.
with? I can only assume that it's been done since then.
And just Ms. Katu, he'll have to answer questions on his own. I want to hear from you as well, and he'll have an opportunity to cross-examine, but we just have to keep the witness testimony separate. All right, go ahead.
Sorry.
That's all the questions I have for this witness.
All right. Does the county have any other witnesses who wish to testify?
Yes, Land Development Director Joanna Katu.
Good morning.
Good morning.
So no disputing that once upon a time there was a billboard here. We have it on our billboard list. I have a 2004 aerial that shows a smaller billboard that's half falling down. No record of any permitting since that time. When this complex was built in 2006, 2007 time, the billboard had to be removed. They can only be on vacant parcels. It's not on the approved site plan for the complex. Sometime since that complex was built, it appeared again. I have a 2019 aerial, so I know it was since 2019 it appeared.
Okay, so just, I have some questions before
Absolutely.
Mr. Hartley. I want to understand your testimony. So I think what you testified to was in 2004, at least as of 2004, there was a billboard there.
It's half up, half down. It probably wouldn't have qualified.
Is that a
but
yes?
It's kind of a yes. You know me. I can't just say yes.
Yeah, no, that's fine.
Yeah.
It's just, it'll help me understand if I just get direct answers.
We can see a billboard on the aerial, yes.
Okay. And it's my understanding, based on your testimony, that at that time in 2004, and the basis for your knowledge is an aerial, correct?
And a billboard inventory showing it previous to that. We know there was one in the 90s there.
Billboard inventory?
Yeah, we have a billboard inventory. In 1998, we sent people around the county all over and took an inventory and marked every parcel where a billboard was. So we know that in 1998, there was a billboard on this parcel.
Was that inventory updated over time, or is it just a snapshot in 1998?
Snapshot of 1998, and not the greatest as far as location.
And it's
but
based on self-reporting?
Self-staff,
Okay.
yes.
All right, so 2004, and it's your testimony that according to the aerial, not the inventory, but the aerial, that the billboard that was present is smaller than the one that is up today?
It does appear to be smaller, yes. Yes.
It appears to be, or?
Yeah, I mean, it's hard to compare aerials, but because one is a developed parcel and one is not, so there's not a lot of perspective there, but it does appear to be smaller, yes.
And I believe it's your testimony that maybe around 2006, the billboard had to be removed?
In '06 and '07, they built that complex. It's there now. And then the billboard had to come off, yes. It can only be on a vacant parcel.
Do you know if it was removed?
It's not on the site plan, but I have no testimony otherwise, but it's not on the approved site plan.
I mean, the issue is, without other testimony, it's theoretically possible that it was still there and maybe a code violation because it was still there.
It could be. I have a letter from the engineer at the time saying all of their signs are 75 square feet and less, or less. So that also leads me to believe that the billboard probably is not in place at that time.
Can you explain to me what that letter is?
The letter from the engineer is part of the review of the complex. They were arguing over signs, and his statement is all of our signs are 75 square feet or less, so they qualify for such and such setback.
Are either the aerials or this review or billboard inventory any evidence that you have available today?
Yes, all of it.
Is it your intention to seek its introduction as evidence?
I can do so, yes.
Well, it's up to the county. I mean,
Sure.
Okay, then I want you to please show it to Mr. Hartley. Anything you want to seek to introduce, I'd ask that you show Mr. Hartley.
No, you're fine.
Mr. Charlton, were there no case resolutions? Were there no case resolutions? Yes, we have. Oh, okay. I'd prefer to take the resolutions first in the future, just, I have no idea how long this will, yeah.
Sorry, don't want to get your stuff out of order.
Well, before I take a look, Mr. Hartley, do you have any objection to these documents?
No objection to them being entered.
Okay, let's enter them. We've got A and B so far. So the aerials, I'll have be Composite Exhibit C, and I will so mark. Okay? Engineer's letter is Exhibit D and is so marked. Site plan is Exhibit E and is so marked. Okay. Okay, so it's the county's testimony that it presumes based on its laws that the billboard was taken down at some point and that the board that exists today is not the same as the original, correct?
That is part of it. The other part is it shouldn't have remained in the first place because it was not on the approved site plan and it can't be on an approved lot.
And would not be on the approved site plan as we sit here today.
Correct.
Okay, I'll let Mr. Hartley cross-examine you. Do you have any cross?
I do. So the Exhibit E that you submitted, you've described as a approved site plan, is that right?
Yes.
On the side of that exhibit, though, it is described as a tree preservation plan. Is that accurate? Sheets involved in the plans that are approved?
Yeah, I have a geometry plan as well. I don't think, it wasn't very helpful. It wasn't as detailed as this one is.
Okay. And the basis for, I understand that it's county's contention that the sign should have been taken down as part of that development, but the only evidence that we're relying on that it was taken down is it based off of a comparison of the 2004 aerial to present day?
I do not have evidence it was not removed other than the approved site plan and the comparison and the lack of permits since then.
Okay. Do you know what the relevant law pertaining to billboards would have been in 1973?
We didn't even have a zoning office in 1973.
So would someone have been able to put up a billboard such as this at that time by right?
No idea, because we didn't even have a planning and zoning office.
I don't have any other questions.
Thank you, Ms. Katu. Does the county have any other witnesses?
No, sir.
Okay, Mr. Hartley.
So based off of the section cited, 9290, specifically subsection B, it states that all billboards legally erected, and if you wanted to follow along, this is on tab B on the folder that I provided.
Let me just make sure, does the county have a copy of?
They do.
Oh, you do? Okay, all right. Then I'm with you on tab B.
So section 9290, billboard, subsection B. It says that all billboards legally erected shall be allowed to continue operation at termination of any easement agreement upon its own terms. I don't think the easement language right now is applicable, but it does say that legally erected billboards shall continue in operation. Continuing further into that section, if we start on the second to last page and subsection L towards the bottom, it goes through a list of things that are allowed to be done to existing billboards, which includes reasonable repair and maintenance. And then going on to the next page, in subsection 2, there are some activities that are prohibited that go outside of reasonable maintenance. The testimony today is that there's no evidence that any of the prohibited acts were done to this billboard subsequent to when it was erected. I don't think that the county has met its burden to prove that there's a violation because they don't know when it was erected, if it was ever torn down, and there was no prohibited maintenance on the record or presented today. So I do believe that since they've cited all of 9290 billboard section, that they would have to prove that it was not exempt under subsection B for the existing billboards.
I will construe that as a motion for dismissal under the grounds that the county's failed to establish a prima facie case. I'm going to reserve ruling on that, and I'd like to hear if you have any testimony.
Yes, Your Honor. I do have Peter Morey, president of Cypress Crossing, the owner here. He didn't come up with me at the very beginning, but if I could invite him up and have him sworn in.
Yes.
All right. Mr. Morey.
Good morning.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
And if you should state your name, please?
Peter Moore.
Now, Mr. Morey, if I could, you may have to share the microphone, but it'll be important that
Okay.
I hear you in the microphone. Now, I heard your answers, so I'm satisfied, we're good. But when you're asked questions, I would just ask that you try to make it known through the microphone.
Sure.
Thank you.
Sure.
Thank you. The majority of what he could and would testify today, I have reduced to an affidavit. It is the document that is labeled as 1 that is in the folder provided to everyone. Mr. Special Master, you do have a signed and notarized copy for your review. If you'd like to review that first, you can do that unless you'd like to hop into testimony.
Well, we can do it one of two ways. I mean, the county can let me know if it objects to the affidavit being an exhibit. If the county does, then I'll want to hear testimony. If not, we can just admit it and they can cross Mr. Morey on it to the extent that it's evidence. Make sense?
Understood.
Does the county have a position or has the county had an opportunity to review the affidavit of Peter Morey?
Just received it today, Judge.
Yeah. So it's up to you. I mean, if you object, then he can give testimony. Otherwise,
Judge, I'd rather him get justice.
okay. I mean, I think that's fine. And
Sure.
please proceed.
All right. All right, Mr. Maury, could you please introduce yourself and explain how you're involved with the ownership of this property?
My name is Peter Maury, and I've been involved with this property since 1973, when my father bought the property from Tony Weber Glass. At that time, this sign was in place, and my dad owned it. I didn't own it at that time. I took ownership at some time after my father died. But I have personal knowledge of that sign being in place all throughout over 50 years. So.
All right. And when is your earliest recollection of that billboard being there?
73, because it was an important part of the advertisement for Weber Glass. Weber Glass sat way back in from the highway behind a bunch of trees, and it was an important part of the advertisement for that company.
All right. Has that billboard been in continuous use since that time?
Yes.
All right. Has it remained substantially the same since that time?
Yes, it's had new plywood put on. You know, it's been maintained, but it has not it hasn't been rebuilt. The posts are the same.
Have you changed the size of the billboard?
No.
Have you raised the height of the billboard?
No.
Enlarged the supports?
No.
Have you added any additional faces to the billboard?
Yes, new faces, different signs and different. Plywood rots after a while, so we put new plywood on there. So.
Okay,
Yes.
but have you added an additional face?
No.
So how many faces does the billboard have?
Just one face.
And it still has one?
Right.
Okay. Have you relocated the billboard?
No.
All right. Has it ever been destroyed?
No.
Has it ever remained void of advertising for longer than 12 months?
No.
Has it ever been in disrepair for longer than 60 days?
But I don't know how you define disrepair, but it's been kept maintained. I'm sure at some point it probably looked bad or something like that, but we've maintained it, best we can.
Mr. Maury, I would ask that you not look at Mr. Hartley's notes. If you're going to testify, just
Oh,
do so
sure.
from your recollection if you can.
All right. Has it ever had any broken supports that haven't been repaired in 60 days or less?
There's been broken supports, but they've been repaired within 60 days.
Has it ever been completely screened by vegetation so that none of the advertising message was visible for longer than 12 months?
No, there's really no tree that blocks it.
Okay. All right, that's all the questions I have for Mr. Maury at this time.
Mr. Maury, did you sign an affidavit today
Yes.
for this case? All right. And are all the statements in the affidavit true and accurate to the best of your knowledge?
Yes, they are.
Okay. Does the county have any cross-examination? I would normally leave it to you if you have any.
Okay, just a couple. Mr. Maury, in 1970.
And if you could, sir, turn on the, yeah, thank you.
Mr. Maury.
Yes.
Good morning. My name is Val Shealy. In 1973, was the current building on the property?
No.
Now, when was that constructed?
Those current buildings were permitted around 2007, 2008, and they were, it's been kind of a process because there's 6 office buildings, so they were built over the next 15 years.
Okay, and that was at your direction, correct?
Right. But the sign was on there was a building on the property. The property was never vacant. We did demolition on that building, Weber Glass, to do the office complex.
Okay, so in 1973, again, I just want to make sure I understand. In 1973, the property was vacant, correct?
No, it was not.
It wasn't?
It had a building on it, yeah.
Okay, but you said way in the back?
Right.
Okay. All right. And when you built the current building, that was at your direction, right?
That was what?
At your direction, right?
Right.
Now, in the submitted and approved site plan, there was no indication of a sign on that, correct?
We do have a site plan with the development plans, and it was approved as far as I know. Didn't see nothing from the county ever that said that we had to take that sign down.
No, that's not what I'm asking. What I'm asking you is this. On the approved site plan, there's no indication of a sign, correct?
Incorrect. There is a sign on the site plan.
So on the approved site plan, is your testimony today, there is an indication of a sign?
Yes.
Okay. All right, that's all I have.
All right. Any redirect?
No, I do have additional exhibits I'd like to enter, so we may need his testimony for authentication purposes.
Okay.
But,
Up to you.
all right. I would like to enter what I've marked as Exhibit 2 into evidence. What this is a composite from Google Earth Street View throughout the years, starting in March 2008, going to September of 2023.
County's position?
I'm sorry.
Do you have any objections to what they have marked as Exhibit 2 being introduced as evidence?
Is that a picture of the current sign?
Do you have a copy of it?
Not that one.
Okay, let me show you.
Oh, okay.
There it is. That's it. And so you can see there, it's from Google, correct?
Google Earth, correct?
Yeah, so it's Google Earth from around March 2008 through 2023.
Okay. No objection.
Okay, we'll admit it. I'm going to have it come in as Exhibit F.
All right, and just to discuss that, as you can see from the earliest that Google Street View would go back in 2008 to 2023, you can see the existing billboard, and it's substantially the same form that it's been since the initial time that we have there. I would also argue that, in my opinion, you can use your own judgment that it is substantially similar to the 2004 exhibit that was provided to you by the county. And then I'd also like to enter what's been marked as Exhibit 3 and 4 in your folder. Exhibit 3
Mr. Shealy, do you have a copy of this? Exhibits 3 and 4 pre-marked?
I do.
Okay, go ahead, Mr. Hartley.
Exhibit 3 is a survey of the property that was done in 2006 prior to the development in 2007. Exhibit 4 is a zoomed-in portion of not the survey itself, but of the development plan that was on the sheets that were also approved in 2007 for the development. As you can see, if you look real closely on Exhibit 3, you will see that the survey shows the sign typical, which is kind of towards the center of the northern boundary of that property. It is admittedly very small, but
I see the sign typical on 4.
And if you look at 3,
Okay.
I think you'd have to
Oh,
flip
I
it
see it.
upside down to have
Yep.
the same perspective,
I
but
see
you
it.
can make it out there as well on Exhibit 3.
Hmm.
And then one that I did not have a large copy of, but my client did bring with me today is the larger copy of the site signage and striping plan from that development that I'll share with them first, and then I'd like to.
Let's
share
talk
with
about
you.
3 and 4. Mr. Shealy, what's your position on these exhibits?
I have no issue with Exhibit 4. I can't see it on Exhibit 3. Okay.
Let's see. It is. Yeah, it says 2006 at the bottom.
On Exhibit 3, if you look just to the right of the existing driveway in the center.
Yep. That's where I'm looking.
You'll see it says sign typical, and then has the 2 indications of the poles just to the
I see
right.
the 2 poles.
And then just to the left below that, it says sign typical, just like it does
Oh,
in the.
that's what that says. Okay. I didn't realize those were words. Mr. Shealy, I can point it out to you if you can't.
I mean, I see what he's saying, I just can't read that, you know. It's supposed to be right here.
What is this?
This is a survey of what's supposed to be the sign.
Oh, what's the date on it?
So right here are the two poles, and right there it says sign typical.
Do we have a date on
It
it?
says September 2006 is the date on there.
So that was before the.
I can read it. I mean, it's a feat, but I can read it.
Before they,
Yeah.
All right, I'm going to admit it. The Exhibit 3 will be Exhibit G. Exhibit 4 will be Exhibit H. And I am so marking in pen on them, okay? And then as for this plan, what's the title of it?
So this is very similar to the tree preservation plan. It's the same property submitted at the same time. The title of this document, though, is Sign, Signage, and Striping Plan.
And are you, we'll need Mr. Maury to testify to this, but are you representing that this is a part of the plan submitted as part of the site plan review and approval?
Yes,
Back in 2000?
2007, 2008, yeah.
Okay, I'd like to know the county's position on it. I hope everyone who came to the hearing today has strapped themselves in for a riveting ride through surveys, tree plans, and so on.
Always try to bring the fun ones, too.
I know, yeah. Well, what's the county's position on it? Does the county object to it being evidence?
Sign typical is not a billboard. You can see the actual
I'll
signs.
allow the county to make comment. I want to know if it has an objection to it being evidence.
To it being evidence, no.
Okay, that's all. Because I definitely want a county to be able to be heard, of course. Thanks. All right, so this will be introduced as Exhibit I, and let me just take a look at it. Now, this looks similar to your Exhibit H. Is Exhibit H a blow-up of a portion of
It
this?
is.
Okay.
Yep.
All right, let me just take a look. Okay. Anything else?
Not evidence-wise, just argument-wise, so
Then before we get to argument, does the county have any rebuttal or commentary on the exhibits introduced? Or cross-examination?
I'm not going to cross, but on the site plan that he's referring to, you can see the entrance signs, the 20-foot by 3-foot. Those are very visible. A sign typical like this would not be a billboard. That is not I see the 20-foot by 3-foot. I also see it farther up as well. That particular marking is usually denoting something like a yield sign on a sidewalk, something like that. I do not at all think that that would actually be a billboard.
Well, do you have any does the county have any cross of Mr. Maury? No. Okay. Then, all right, then I'll allow the county this will be part of its closing, summation, whatever else the county wants to say to me about this case, now would be the time. And we'll also hear from the public. Do you have anything?
Are you going to allow them argument first?
No, I'm going to have you argue first.
Well, Judge, I think the strongest evidence in this case that this billboard was not there is the site plan that was submitted at Mr. Moore's direction. On that site plan, there was no indication of a sign because they were told they weren't allowed to have a sign because the property would no longer be vacant. Now, he can testify here today that there was, but the site plan that was submitted by the county clearly shows there was not a sign, indication for a sign. That's the strongest evidence. Now, we can't control, once the property is developed, what they do afterwards. And what they did is they put a new sign up. Even the pictures from years ago that shows a decrepit sign, that's not the same sign. But the strongest evidence is that the site plan that was submitted at Mr. Moore's direction did not have an indication for a sign because they were told they couldn't have a sign. Now they have put one since they've developed the property, and that sign is in violation.
Okay. Mr. Hartley?
Yes, Your Honor. So my understanding of the county's position of the violation is that this sign was erected sometime after 2004, based off of the aerial that was shown, which they contend is a separate sign. The survey is from 2006, the survey, not the site plan, which shows this typical sign. If you compare the Google Earth street views with the existing sewer to where the sign is located, you'll see that where the sign typical is located is exactly where this billboard is, with the two posts identified on both the survey and the site plan, including the blown up picture, being in the exact same location as this billboard, which the sworn testimony and affidavit corroborate being there since 1973, with no changes other than allowable maintenance since that time. I did the blown up picture, which is Exhibit F. I did receive from Engineer Ken Ward, who works for Troy Burrell, who you got the letter from the county. In my discussions with him, I don't have him here today. He has indicated that is also his understanding that this was the existing billboard that is there. In my motion to dismiss the notice of hearing, outside of the factual description, which I do think would have been beneficial, was also the exhibits. If I would have seen the tree preservation, we may have had Mr. Burrell here, but nonetheless, I do think that the evidence shows that this sign was erected sometime in 1973 or prior to, that it has not been modified in a way that would make it an illegal non-conforming billboard, and that there is no violation here based off of its existing use. Per the code, they do have a way to sunset these things if it is ever destroyed or any of the alterations which are prohibited were undertaken, but I don't think the evidence shows that that is the case here today.
So in a negligence case, it's always the advocacy of the plaintiff who says the defendant could have done more. The defendant could have done more. And here, I hear the argument about notice as there could have been more notice. And I agree, there could have been a more factual basis. But in a case like this, due process is satisfied when something, I think this notice is provided. I think you're both right to some degree. And I think that the county is correct that the billboard sign does not appear on the site plan, but I don't think that's the violation noticed here. I mean, if it's a violation of a site plan or something like that, that's a different section in your code. I just don't have the evidence to sustain that this is a violation of 9290, so I'm going to find in favor of respondent. Oh, I'm sorry. Well, maybe the public can dissuade me. Are there members of the public? Are there members of the public who want to be heard on this? I did say I'd hear from you. I do. Thank you. All right. No comments from the public. Thank you.
Thank you.
May we have the survey back, or do you need to hold on to that?
It's evidence.
Okay, I have a digital copy. Thank you, Your Honor.
Thank you.
Okay, next case, we'll start with our no contest. We have a no contest for Janice Catherine Bennett, case number CE 2026-1009. That no contest is for 45 days at a $50 a day.
What is it again, Mr. Charlton?
The no contest, the case is for Janet Bennett, Catherine.
I'm just sorry, the number of days and dollar?
That would be at 45 days at $50 a day.
Okay.
And that is page 6 of your agenda.
Good morning. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
If you'll state your name, please. Janice Bennett. Thank you.
Alan Jonasson, Citrus County Code
Good morning,
Compliance
Mr.
Officer.
Jonasson.
Good morning, sir.
Could you please speak in the microphone? What is your name?
Janice Catherine Bennett.
Okay, Ms. Bennett. Have you heard the terms of the resolution as announced?
I have.
Okay, and my understanding is that there's going to be, basically, you're not contesting that there's a violation on the property. However, the county has agreed to allow you 45 days to bring the property into compliance. If it's not brought into compliance within those 45 days, there would be a $50 a day fine.
Yes, sir.
Okay. Mr. Joseph, can you just tell me a little bit about?
Yes, sir. So there's a storage container on the property, and they're going to remove it.
Is there anyone from the public who wants to be heard on this case? That sounds like a reasonable resolution to me, and good luck. Also ordered.
Thank you.
Our next case is Casey Brian David, case number 2026-731, Code Officer Alan Jonasson. This is a no contest as well at 60 days and $50 per day. And that is page 4 on your N4 packet.
Good morning.
Good morning.
Good morning. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Absolutely.
If you'll state your name, please.
Brian Casey.
Thank you.
Okay. Good morning, sir. And what I heard was that there's essentially an agreement that you'll agree that there's a violation on the property, but be given 60 days to bring the property into compliance. And if it's not brought in compliance within those 60 days, there would be a $50 a day fine. Is that correct?
Yes, sir.
Just so folks know, I mean, $50 a day is definitely the least that the county is ever willing to agree to. So that's a pretty good deal. Mr. Jonasson, can you tell me about
Yes, sir. This is a storage on a vacant. There's a shed on the property, and he has indicated that they're going to remove it.
Okay, does that all sound right to you?
Correct.
Anyone from the public who wants to be heard on this case? Sir, did you have, oh, no. All right, I don't see anyone. Then I will so order it and wish you luck.
Thank you.
Thank you.
Good luck to you, sir. Yes, sir. Thank you.
All right, our next no contest cases are for Samuel Esposito. It is case numbers 2026-756, 757, 758, and 759, and that is at 90 days at $150 per day.
Okay.
Good morning. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
If you'll state your name, please.
Samuel Esposito.
Thank you, sir.
Good morning, sir.
I know.
All right, so my understanding, Mr. Charlton, let me just clarify. So it's 90 days and $150 a day. Is that for every case?
Yes, sir.
Okay. Mr. Esposito, so my understanding is that you're willing to plead no contest. Okay, meaning that there's, in each of these 4 cases, and they're each a different code section, but I think for the same property, that there's a violation. And to the extent that a violation exists in any of them, you're going to have 90 days to fix it. If in any of these cases you're not able to bring it into compliance within 90 days, there would be a $150 a day fine. Does that make sense?
Yes.
Meaning, worst case scenario, at the end of 90 days, and you haven't brought any of them into compliance.
I was starting.
Okay, but I just want you to understand, I have to explain this. You're essentially looking at $600 a day if none of them are brought into compliance. Make sense? Is that a yes? All right, I just want to make sure. Is there anyone from the public who's going to want to be heard on any of these 4 cases? I don't see anyone. Mr. McGuire, can you tell me a little bit about what's going on?
Yes, sir. I've been in contact with Mr. Esposito since day one. It's multiple addresses, but the same violations, junk and debris and unlicensed vehicles. When I spoke with him yesterday, he had started making improvements and just simply said that he needed more time.
Okay. Sounds good. With no objections, I will go ahead and issue the orders finding that a violation exists in these cases and giving you the 90 days, sir.
All right, thank you.
Good luck.
Our next no contest case is Jane Chozick and Brian Deal, case number 2026-690, Code Officer Robert De Niro, page 5 of your N4 packet, and that is at 60 days at $50.
No, 150.
At $150, my apologies.
If you'll raise your hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
If you'll state your name, please, sir.
Brian Deal.
Thank you.
Good morning, sir.
Good morning.
All right, so what I've heard is that and Mr. De Niro, have you been sworn in?
Yes, sir.
Okay. What I've heard is that there is a resolution that you'll plead no contest, essentially, that there is a violation on the property, but you be given 60 days to bring the property into compliance before any fine begins. And if there is to be a fine, it would be $150 a day. Is that correct?
Yes, sir.
Is there anyone from the public who's going to want to be heard on this case? Again, I don't see anyone. If I'm wrong, raise your hand. Mr. De Niro, tell me about what's going on.
Accumulation of junk and debris amongst the property. Mr. Deal has substantially cleaned a lot of it. He doesn't have a vehicle, so he just needs a little bit more time to take care of the property.
Okay. So you're willing to go down to 150 based on his good faith and his working with you?
Yes, sir.
Okay. I have no reason to get in the way of that. I'll give you the 60 days, and good luck.
Thank you.
Thanks.
Next case that we have for no contest is Mary Jean, John McGrath, and Christina Mary Pitts, and Darren Zachary. Case number CE 2026-974, Code Officer Cody McGuire, page 12 on your Acela packet, and that is at 60 days at $100 per day.
Good morning.
Good morning.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? If you'll state your names, please.
Jean Mary McGrath.
Christina Mary Pitts.
Zachary Duran Pitts.
Okay. Good morning, all. All right. So what I've heard is that the agreed resolution is you'll acknowledge that there is a violation on the property. However, I will give you 60 days to bring the property into compliance, and if it's not brought into compliance as ordered, $100 a day. Is that what you've agreed to? Okay. Mr. McGuire, what's going on?
So this is a junkyard case. It's not like our standard discarded automotive parts. It's feed bags, twine, some discarded pallets and stuff like that. But 60 days should definitely bring them into compliance.
Okay. Is there anyone from the public who wants to be heard on this case? I don't see anyone. So I'll go ahead and sign that order and give you 60 days. Good luck.
Thank you.
Our next no contest case is Sharon M. O'Connell, Living Trust, dated January 12th, 2009. Case number CE 2026-948, Code Officer Alan Jonason, page 13 of the Acela packet, and that is at 2 weeks, $50 per day.
Yes, sir.
The case number I have is 26-954.
Yes, sir.
Oh, okay. All right.
Good morning. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
If you'll state your name, please.
Joseph O'Connell.
Thank you.
Good morning, Mr. O'Connell. And are you an owner or tenant of the property?
I'm the trustee of the trust.
Oh, you are the trustee. Okay, gotcha. All right, so what I've heard is that you're conceding that there's a violation on the property. However, we've agreed that you'll have 2 weeks to bring the property in compliance, and if it's not brought into compliance as ordered within the 2 weeks, 14 days, there'd be a $50 a day fine. Is that right?
Correct.
All right, what's going on?
Yes, sir. Simple junk case. There's a small little vanity and a couple little things in the backyard. Shouldn't take more than a couple days, but we agreed to
Couple
2
hours?
weeks. Just, well, yeah,
Okay.
absolutely.
All right.
Absolutely.
Is there anyone from the public who wants to be heard on this case? Okay, then I will go ahead and sign that order, give you 2 weeks. Good luck.
Thank you, sir.
Thanks.
Our next no contest case is James and Angeline Pantages, case number CE 2026-1083, Code Officer Julie Wilkinson, page 14 of your Acela packet, and that is at 45 days, $50 a day.
Good morning.
Good morning.
Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
If you'll
Yes.
State your names, please.
James Pantages.
Good morning.
Julie Wilkinson.
Thank you.
How do I pronounce that? Pantages?
I'm sorry.
How do I pronounce your last name?
Pantages.
Is that Greek?
It's Greek. Yes.
Okay. I've known some Pantazises, and it seems very similar. All right, so what I've heard the terms as being is grant you 45 days to bring the property in compliance and $50 a day if it's not brought into compliance within the 45 days. Is that right? Is there anyone from the public who wants to be heard on this case? The county's just handing these out, $50 days. Okay, I have no, well, actually, tell me what's going on the property.
It's a simple junk case. There's a fairly large pile of loose trash and debris in the property.
Okay. Well, very good. Then I will sign the order granting 45 days, give you time to comply. Thank you, sir.
I appreciate it. Thank you. Thank you very much. I appreciate it.
Our last case that is no contest is Ronald Sappenfield. And that is in your Acela packet. That is case number CE 2026-1001, Code Officer Cody McGuire, page 17 of that agenda. And that is at 45 days at $100 per day.
Good morning. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. If you'll state your name, please.
Ronald Dean Sappenfield, Jr.
Good morning, Mr. Sappenfield.
Good morning, sir.
All right, so I've heard that the terms are you'll acknowledge that there's a violation of the property, but I would give you 45 days to bring the property into compliance, and if it's not brought into compliance as ordered, $100 a day.
Yes, Your Honor.
Okay. Is there anyone from the public who wants to be heard on this case? Mr. McGuire, what's going on?
So Mr. Sappenfield's got a vacant piece of land and he's storing a shed, like a mobile home, and just loose trash and debris and stuff on it.
Okay, well, it sounds like that's a fair resolution to me. I will grant the order, giving you 45 days, $100 a day, and wish you luck.
Thank you, Your Honor.
Thank you.
And that is it for our no contest cases.
Very good.
Our next case on the agenda, J.B. Jones Jr., Fish Eating Creek Trust, case number 2026-752, Code Officer Julie Wilkinson, page 11 of your agenda.
Good morning.
We'll talk about it.
Good morning. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. If you'll state your name, please.
Austin Davis.
Thank you.
Mr. Davis? Okay, very good. Good morning. Well, it's
Through that door.
I think it's just the emergency door, maybe?
Those main doors right there, yeah.
Yeah, all right. We're not, as the warden in Shawshank Redemption said, nothing stops here. Okay, so, go ahead.
This is Julie Wilkinson, Citrus County Code Compliance Officer. This is case number 2500752. Excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20-61 of the Citrus County Code of Ordinances. The address is 23 South Wadsworth Avenue in Beverly Hills. Property owner is J.B. Jones Jr. and Fish Eating Creek Trust. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on June 26, 2026, photos from a corrective action inspection on July 15, 2026, and photos from my final inspection conducted on August 18, 2026. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
Can you give me a narrative of what's happening?
Yeah, so we got a complaint for some vegetation being piled up in the easement area along the back of the property. I have had contact with the property owner and with Mr. Davis here, and he cleaned up vegetation that was not part of the case, but it's looked great. But the vegetation in the back part of the property still is there. And I believe he has an explanation for that.
Okay. Then let's first talk about who you're here for, Mr. Davis. So you're not, in fact, an owner of the property?
No, sir, I'm here on behalf of them for Fishing Creek.
Is this, so you're not a trustee of the trust?
I'm just one of their employees that was
Gotcha.
actually handling it, so that's why they wanted me to come here and do it.
Okay. Well, this is a question for the county. Ms. Harrison, I would expect, might object usually at this point, or Ms. Antrim would have, but it's up to you. I don't know. Being an employee of the company, I'm inclined to listen, but what's your take on if he has standing?
It's the employee?
Yeah. Do you think he has standing to stand here in the shoes of the owner versus just a member of the public?
No, I don't think so.
Okay. All right. So tell me a little bit about what you've come here to say.
So for the overgrowth, for all the vegetation that's in the easement, it is on our property. I'm not saying it's not, or their property, sorry. They bought the house in foreclosure auction. The house has been vacant for years beforehand. So the whole vegetation along their fence line on their property along the easement has grown over 10 feet tall, I would say, right around that range. And the easement is probably a 5 feet wide, 5.5 foot tall by like 30 feet long. And it's just stacked of these branches that are not from the property. I've showed her the proof. I've jumped over the fence, picked them up, said none of these branches are from ours. There's still branches hanging from the neighboring backside house, hanging over the fence where he's throwing them in. There's branches there that aren't even fully dead. All the branches there are shorter than all the ones that are there, and they've been cut at the base.
Why is that a defense?
It's illegal dumping on our property, and he's calling code to have us come pick up his trash.
I got you. Well, let me ask, is there anyone else from the public who wants to be heard on this case? I think I agree with the county. I'm not sure you have standing to actually stand in the shoes of your boss, but I'll take the comments and respond to them. Be that as it may, from a county code perspective, when there's a growth of vegetation, it's still the owner's liability to clean up the property. Now, regardless of how it got there, for better or for worse. And so what the respondent in this case has to do, if they think someone else is liable, is ask them to do it, sue them to do it. I mean, consult a lawyer, figure out what the remedies are, but the county has to enforce its code in the meantime. So what are your exhibits, Ms. Wilkinson?
My exhibits are photos from the inspections and the notice documents.
Yeah, let me take a look at them. He doesn't have standing, so I mean, without objection, exhibits A and B are evidence, and I'll just take a look. I mean, if I was in the respondent's position, I'd say the same thing. It hardly seems fair, but it's the way that it is. So they cleaned up other stuff?
Yeah, they cleaned
Made
up.
it look good?
It looked good, but it wasn't part of the case. I told him, it looks great. It wasn't required.
Yeah, no, hey. Some deeds go unpunished, but not all. All right, so I've admitted exhibits A and B. What's the county's recommendation?
The county's recommendation is $100 a day.
Okay, I'm gonna grant 45 days, and we'll say $100 a day if it's not brought into compliance as ordered. So I'm gonna issue that order in writing, and we'll send it to the owner, but I don't think it should take that long to clean, and I've given more time than I normally do because obviously they're working with the county, so good luck.
Thank you.
Next case, Violet Runzowski and Robert Jack Braden Jr., case number 2026-678. Code Officer Robert De Niro, page 12 of your agenda. Expert on the case, Land Development Director Joanna Coutu. And that is the last case for the N4 packet.
Okay. Give me 1 second.
Very good.
Yes, sir. Robert De Niro, Citrus County Code Compliance Officer. This is case number 2026-00678. Special requirements for all accessory uses, a violation of Citrus County Land Development Code 3102A. The property is 11351 South Kelsey Terrace, Homosassa, Florida. The property owners are Violet Estelle Ronkowski and Robert Jack Brandon Jr. Posting of good service via posting of hearing at the property and the La Quinta Government Building. I'd like to authenticate the following documents and request them to be admitted into evidence. Photos taken on my initial inspection on May 12, 2026. Photos taken during my corrective action inspection on June 3rd, 2026, and my photos of my final inspection conducted on August 17th, 2026. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, copy of the general pre-hearing order, a copy of a photo of the notice posted of hearing posted at the property, and a July continuance letter and the posting affidavit.
Okay. Is there anyone from the public who wants to be heard on this case, or anyone on behalf of respondent? All right, then the exhibits will be admitted without objection. I'll take a look at them. Thank you. Well, this isn't exactly Columbo. It looks pretty clear.
Yeah, it's pretty cut and dry.
No one knows who Columbo is anymore.
I do, unfortunately.
Okay.
I think
if we took a poll, I guarantee
I believe
you
a few
there'll
of
be a
us do.
clear age demarcation.
I believe a few of us do.
All right.
Yeah. No, she's a lot
I'm trying
younger.
to say it's a
She's
good
very
thing we're
young-
getting older, but no one knows who Columbo is. All right. So it looks pretty clear from the photos, but tell me what's going on.
Yes, sir. This is a vacant property that is zoned 1.7 acres and zoned low-density coastal lakes. On May 12, 2026, I conducted an initial inspection and observed a mobile home, a RV camper vehicles, along with miscellaneous items on the property. On May 12, 2026, a notice of violation was issued for special requirements of accessory uses. On June 3rd, 2026, I conducted a corrective action inspection and found that the property had remained in violation and issued a notice of hearing. I've had no contact with the owner as of my final inspection on August 17, 2026. The property remains in violation. My expert on this case is Land Development Director Joanna Coutu.
Yeah, this one's a bit of a puzzler. I'm sorry, Joanna Coutu, Land Development. They did get a mobile home permit in 2023. It was issued. They went all the way to final inspection and passed, but they didn't get their CO. For some reason, they didn't get their septic final and never did. And I talked to the health department again yesterday. Their permit is also expired. So both the building permit and the septic permit never were finished. They never got their certificate of occupancy. So they can renew them, sure, but right now it is still a vacant parcel because they have no CO for either one.
And it's a junk case, even if they did
The
have.
extra stuff, yes, there's
Yeah.
some other stuff on there.
Do we presume that there's septic on the property currently, even though it hasn't been, we don't know?
It was expired in 2024, so we just don't know. They
Yep.
never got to do their final inspection.
Okay. And you've had no contact with them?
No, sir.
Okay, what's the county's recommendation?
$150 a day along with administrative costs.
How long does it take to do the permit process?
A mobile home and septic, I'm not sure. A mobile home would be very quick within a few weeks.
Okay. Okay, 30 days, $300 a day.
Yes, sir.
Next case, A&M Properties Investment LLC, case number CE 2026-1027, Code Officer Julie Wilkinson. Page 5 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Good morning.
I do. Wagner Mesquita de Oliveira.
Could you please
Sorry for the-
state that again?
Wagner?
Wagner?
Yes. Mesquita
Mesquita?
de Oliveira.
De
Oliveira.
Oliveira.
Yes.
Thank you. Okay.
All right, this is case number 2601027, special requirements for all accessory uses, a violation of Citrus County Land Development Code 3102A. The case number is excuse me, that case abated. The address is 1298 West Galgano Street in Dunellen, Florida. The property owner is A&M Property Investments, LLC. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on June 23rd, 2026. Photos taken during a corrective action inspection on July 8th, 2026. Photos from my final inspection conducted on August 18th, 2026. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
Can you tell me a little bit about what's going on?
So this is a vacant property, and they were doing some construction on it with a permit, but the construction has stopped and the permit has been expired since December 14th, 2025.
Okay. Then I would ask that you show your exhibits to Mr. J. Oliveira and okay, you're good. No objection then. We'll have exhibits A and B as evidence. And I will just take a brief look so I know what the county's talking about. Looks like a good enough slab. Okay, go ahead.
This is a vacant property, 0.32 acres and zone planned residential development. On June 23rd, 2026, I conducted an initial inspection and observed a concrete slab and construction material on the vacant land. There was a building permit that has expired on December 14th, 2025. I also observed an overgrown lawn with weeds in excess of 18 inches, but that has since been remedied. On June 24th, 2026, a notice of violation was issued for special requirements for accessory structures, uses. And on July 8th, 2026, I conducted a corrective action inspection and found the property still being used for storage with no active building permits. As of my final inspection on August 18th, 2026, the property remains in violation. I have just had contact with
Wagner.
yesterday, through email yesterday.
And what was the nature of the contact?
He was informing me that they had gotten the weeds cut down, and so I went out to do an inspection and closed that case.
Very good. All right, Mr. J. Oliveira, what's going on?
Morning to all. I got two sets of response and exhibits.
Please share it with the county.
With the county, yes, and the special magistrate.
If you would, bring it on up. Thank you.
I'd like to ask permission also to read a brief test, a summary test, because my English is a work in progress, so I'll save time for everyone.
Well, go ahead and tell me what you need. I'm not looking at anything yet.
Okay.
I want to hear from you first.
Yeah, I have a summary for that.
Good.
So, my name is Wagner Oliveira. I'm an authorized member of AAM Properties Investments, the respondent in these cases. I have filed a written response with exhibits. Sir, I do not contest the conditions described in the notice exist. With respect, A&M have some objections pointed in our written response, and I raise it only to preserve the record, not to take the county's time in this morning. Subject to that, I ask to be heard only in 2 points: the time we need and the fine. A&M is sorry for these conditions occurred. The responsibility for these properties is ours, and we take it. The work has been done. In July and August, we hired and paid a contractor to cut the vegetation and remove the construction debris. The invoices and receipts are in Exhibit C. The work at Baitstraw was finished in August 5th, 8 days before the compliance date. I regret I did not report to the division in time. I have now reported in writing. Because of this matter, it's simple. Our general contractor, Martin's Development LLC, working 2025, let both building permits expire. We wrote to that contractor 3 times in May of this year, asking for new time, a new,
Timeline
yeah,
to figure out.
timeline to
Yeah.
begin, yes, that's it. And we received no answer. We filed a suit on Orange County against them, and the case is pending. We're not asking this county to solve that dispute. Sir, A&M has confidence in these courts and in the institutions of this country. That is the path we chose, and that is how we intend to resolve this. The notice for Bedstro says the violation can be cured by getting a new building permit. That is the path we have taken. We have served formal notice to the prior contractor. We are engaging a substitute licensed general contractor, and we ask for 90 days to file the permit applications. Nowadays, since we are in the court, I can't get direct contract with Martins. I have to do it through the attorney and wait for them for 30 days because of the contract. That was what was told. Yeah, yes. We respectfully ask that no fine be imposed by now. A&M has already spent $4,600 of its own money on this work and is carrying the cost of 2 unfinished houses. Every dollar taken now, it's a fine. A fine is a dollar that does not go to the permit and the construction. A fine today would delay the very compliance the county is asking for. Whatever this office decides, A&M will keep both lots mowed and clean on a 30-day cycle until the houses are finished. Thank you all.
Okay, so basically, você precisa mais tempo.
Jeez, you see.
Okay. Has the county had a chance to look through the documents that are submitted? This is a very comprehensive, detailed, candid defense. Does the county have any objection to the documents being introduced on respondent's behalf?
No.
Okay. Then I'll go ahead and allow respondent to lay this record and admit this. First, I'll deem the written response to the notices of violation as filed, and respondent's exhibits A through E will become exhibits C through G in our record. Does that make sense?
Yes.
Okay. What's the county's recommendation?
$100 a day.
Okay. You've asked for 90 days.
Yes.
Okay. Do you understand what you need in order to bring the property into compliance? Essentially, either to get rid of everything or, I believe, to renew the permit and have it issued? I mean, does the case abate when it's issued or when it's applied for? Yes. So you need to have the permit issued within the time that I allow. Make sense?
Yes.
You need more than 90 days.
Yes,
you do.
Yes, please, because I have a contract with the previous general contractor, and I have to ask him I have to wait for 30 days for them to make the statement about, and then, Your Honor, it's been very hard to find another general contract that accepts to finish the houses.
Well, that's the thing. I don't think it depends. Personally, I mean, I don't think it depends on your prior contractor. I think you need a new contractor to come in, take over the permit.
Yes, I do.
Right?
I think I can get one.
Yeah, you can.
For sure, I can get one. And I can get him applied and make evidence to the court that I got one.
Yeah. Is there anyone from the public who wants to be heard on this case? Okay. I'll give 120 days. If it's not brought into compliance, $100 a day.
Thank you.
Good luck.
Thank you, sir. Thank you all.
Our next case, Richard J. Ellis, case number 2026-937, Code Officer Alan Jonason, page 8 of your agenda. Continue.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 2026-00937. Accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address of the violation is 1479 East Winnetka Street, Hernando, Florida. Property owner is Ellis Richard J. This property is 1.25 acres and is zoned LDR-MH and was purchased on 1 December 2008. I have good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 11 June 2026, photos from my compliance inspection on 13 July 2026, and photos from my final inspection conducted on 18 August 2026. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a photo of the notice of hearing posted on the property, a copy of the pre-hearing notice, a copy of the posting affidavit, and a copy of the property appraiser.
Without objection, what's been proposed as Exhibits A and B is evidence.
Yes, sir. On 11 June 2026, I conducted my initial inspection and observed the property to be in violation with household trash and miscellaneous junk and debris on the property. On 11 June 2026, a notice of violation was sent via certified mail for junkyard conditions, which is a violation of the ordinance I mentioned earlier. On 13 July 2026, I conducted a compliance inspection and observed that the property remained in violation and a notice of hearing was issued. I have not had contact with the property owner, and as of my final inspection on 18 August 2026, the property remains in violation.
It's a shame. It's otherwise a pretty nice
It really
looking
is.
property.
It's, yeah, and that stuff is off to the right
Yeah.
in the rear of it. Kind of difficult to photograph, but
Wow.
definitely a pile of trash and stuff.
Okay, what's your recommendation?
$100 a day, sir.
Is there anyone from the public who wants to be heard on this case? All right, I'll give 14 days and $200 a day.
Thank you.
Yep.
Next case, James P. Gilly, case number 2026-1039, Code Officer Cody McGuire, page 9 of your agenda. Expert on the case, Land Development Director, Joanna Coutu. Good morning.
Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
If you'll please state your name.
James P. Gilly.
Good morning, sir.
Good morning. How are you this morning?
Good, how are you?
I'm all right.
Please proceed.
All right, Cody McGuire, Citrus County Code Compliance Officer, case number 261039, a violation of the Citrus County Land Development Code, section 4002, site development without a development order or permit. The address is 4471 West Denellen Road, Florida, and the property owner is James P. Gilly. Good service via posting the property and at the Lecanto Government Building. And I'd like to authenticate the following documents and request that they be admitted in the evidence. Is it Exhibit A, photos taken during an initial inspection on July 14th of 26. Corrective action inspection, and my final inspection on August 17th of 2026, and a photo of from the property appraisers dated June 22nd of 2025. And Exhibit B is a copy of notice of violation, copy of notice of hearing, copy of the general pre-hearing order, and photos of the property posted and a posting affidavit.
What's happening on the property?
So Mr. Gilly has this property, and it seemed to be like the front portion of it had a few trees removed and light groundwork done.
Can you repeat that?
A few trees removed from the front portion of the property and then groundwork done.
Groundwork done. Like grading or?
Yeah, grading.
Okay.
Grading and removal of like dirt and maybe some roots.
Okay. Can you show the documents to Mr. Gilly? And do you have any, I want you to look through these documents and let me know if you have any objection to them being evidence in this hearing.
I didn't see that.
So this was on your property.
Yeah, I didn't.
To let you know that.
Is that on there now?
It wasn't there yesterday.
I was gonna say, because I never got that.
And then this is the affidavit saying that I put it on the property.
Okay.
And then this is the pre-hearing order.
Sir, do you have any objections?
No, I don't.
Okay. I'm sorry? Bless you. Just for the record, Mr. McGuire is reordering them for my benefit. All right, so I have Exhibit A. I think you've got Exhibit B. That's okay, that's fine. Thanks. All right, so Exhibits A and B are admitted without objection, and I will just take a quick look through it.
That area is 95 by 100 feet,
Okay,
9,500 square feet.
so less 9,500 square feet,
Yes.
basically. Okay. All right, please proceed.
All right, this property is listed on the property appraiser's website as vacant and is 0.712 acres and is zoned CLR. I conducted my initial inspection on July 14th and observed that there was trees removed and some groundwork done. While researching the property, I observed that there were no permits applied for or issued. And as of my final inspection on the 17th, the property remained the same as my initial inspection.
All right, Mr. Gilly, what's going on?
Well, what happened is back, I used to have a nursery on that property, so it had a lot of ground mat and staples on there. And back in 2021, when my brother, he was on 4449 was his lot, and mine was 4471. The nursery went through to both of them. Well, when he sold his property, it kind of got defunct. I had a fence up and everything, and I cleaned up all the containers and the dirt and all the mishmash, but what there was still ground mat down with the staples in it. And I tried to pull it up, but with the way that stuff had grown through the mat, you just couldn't do it. You know what I mean? And there was over 1,000 staples there. And there was,
Sorry, ma'am. Yeah, I mean, ultimately, I'll ask if he has any other witnesses, and I'll welcome your testimony. But
anyway, there was it was 121 feet across, 100 feet deep, 12-foot rolls, 12 foot by, you know what I mean, ground mat with staples every 3 feet in each row. So, and I tried to get it out by hand, but you couldn't do it with the way it was. So what I had them do was come and scrape the top. Basically, they got right underneath the ground mat and scooped it up.
Mm-hmm.
I didn't take any surface dirt. I've got pictures of on top of the ground mat. It looks like it's just dirt, but it's, you know what I mean?
feel free to show to Mr. McGuire, and
You see how that's dirt with the ground mat? You see how the ground mat's,
Yes, sir.
and you see how the stuff grows over the top of it like that? That's what it looks like new. But when you got stuff growing through it like that, and then what happens too is when you roll it up, some of the staples are rusted across the top, so then you got spikes sticking up. So I was having a lot of trouble with that too, so I figured the best thing to do would be to basically scratch the top layer off to do. I was trying to restore the land back to the way it was before I put that ground mat down. Was my goal, was to
you
restore
want to
it.
introduce that document as evidence at this hearing, the picture? It was a piece of paper.
So I've got pictures of it. See, like, there's.
I'm implementing a no licking rule. No more licking of the pages before introduction into evidence. But whatever photos you want to have introduced, I want to see them, but first show them to the county so they can object or not.
This is the side where I didn't do any scraping on that side of the driveway. And this looks like just regular land, but underneath that is ground mat. see stuff like that. You can't get that up by hand, especially with that stuff growing through it. And there are pictures of some trees, but in other words, I was just trying to restore the property.
I
and
get it.
I didn't realize I needed a permit to do that.
And most people don't, but have you given Mr. McGuire all the photos that you want to introduce as evidence?
I think so.
All right, Mr. McGuire, can you show them to the county attorney?
Yes, sir.
Okay.
I don't know how many more you want me to show you.
It's up to you. It's your evidence.
The whole folder, what I would do. And there's a piece of ground mat in there as well, and then I have some more photos.
I can't listen to you until it's your turn, ma'am, so give me one moment.
Helping my dad.
This is what the ground mat looks like. And, I mean, it's so brittle that you can't pull it out by hand.
Okay.
It's just,
You want this to
Do you want to introduce an evidence? Okay.
back in 1968,
If you just, I want them to be able to hear you, so. Okay. Does the county have any objection to respondents' proposed exhibits? Okay. Then we'll admit them. First, the tangible material will be Exhibit C, and then the pages I will have as composite Exhibit D altogether, and I will take a look through them.
the live oak is the edge of the wetlands. Everything in front of that live oak is, in other words, I knew where the wetlands were when I went in there. When I first bought it 25 years ago, we did a wetland delineation, so I knew anything in front of that live oak is,
Right.
anything behind the live oak is wetland. So I stayed 40 feet from, when they graded it, I purposely kept them back. So
Yeah,
that they wouldn't.
it
be
appeared to be just like the front portion of the property.
Right.
Yeah.
Like I said, it's 95 by 100 or 96, whatever. it was.
Right.
I had
Do these exhibits change the county's
96.
position at all, or in part?
No, sir.
No. Okay. So, Mr. Gilly, the problem is, I think these photos are useful, and I think this is useful to understand where you're coming from and why you shouldn't be unduly punished or penalized, if that makes sense.
I was trying to do the right thing.
Exactly.
I
And
didn't want to leave all that non-organic material
I
on
don't
there.
construe it as a traditional
I was bound
site
to
mod,
take it
where
out of
some,
there.
hold on, sorry. I don't construe it as a situation where someone is trying to get around the permitting requirements for clearing a property, and sometimes people do. Now, if you want, you can have another witness testify. She's been waiting.
She just wanted to show you pictures of the ground mat.
Well, and if it's on the phone, I can't take it and I can't look at it. These are very comprehensive
Okay.
photographs,
All right.
but it's up to you. I mean,
Well, the
if,
thing is, she had pictures of when you hold the ground mat up and you see the staple sticking through.
and I believe, but you've already testified to that, and there's nothing to the contrary. I accept that as true.
I understand that.
I
Okay.
accept it as true. What's the county's recommendation?
A one-time fine of $1,000.
Okay, so normally what the county does is recommends $5,000. And I won't put words in their mouth, but I think they understand the circumstances behind this property. I've never really seen them go lower than 2,500, so I am going to find that there's a violation and do the $1,000 fine. The reason, Mr. Gilly, is that as difficult as it is, we have to hold the line on what this law says. Otherwise, a lot of people out there do it for the wrong reasons. They do it for the wrong reasons.
I completely understand.
Okay.
If I'd have known I needed a permit, I would have pulled one.
Oh, I know. Is there anyone from the public who wants to be heard on this case? Then that's it, and I just wish you good luck.
Thank you,
All
Your
right.
Honor. Thank you.
Next case,
From here.
David and Teresa Luz, case number 2026-993, Code Officer Cody McGuire, page 10 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Good morning. Morning. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
If you'll state your name, please.
David Luce.
Thank you.
Good morning, sir.
Morning.
All right, Cody McGuire, Citrus County Code Compliance Officer, case number 260993, a violation of Citrus County Land Development Code, section 4002, a site development without a development order or permit. The address is 5386 South Forest Terrace in Homosassa, and the property owner is David Luce and Teresa Luce, and I have good service via posting the property and at the Lecanto Government Building, and I'd like to authenticate the following documents and request they be admitted into evidence. Is Exhibit A, photos taken during my initial inspection on June 12th, and photos of my final inspection on August 17th, and aerials from the Citrus County Property Appraiser's Office dated July 17th of 2025. Exhibit B is a copy of the notice of violation, copy of the notice of hearing, copy of the general pre-hearing order, and photos of the property posted and a posting affidavit.
Can you tell me what's going on?
Yes, sir. So I came in contact with Mr. Luce on one of my inspections, and he told me that he had the trees removed because some of them were diseased, and then other trees were removed along the process.
Okay. So this is a tree removal?
Yes, sir.
Okay. Sir, can you take a look at the documents he's going to show you and let me know if you have any objections to them being evidence in this case?
I got no.
Okay. All right, then Exhibits A and B are admitted as evidence. And while I'm at it, is there anyone from the public who wants to be heard on this case? I don't see anyone. Okay, please proceed.
This property is listed on the property appraiser's website as vacant and is 0.508 acres and is zoned RUR. I conducted my initial inspection on June 12th and observed that the trees had been removed. While researching the property, I observed that there were no permits that were applied for. And then while coming in contact with Mr. Luce, he confirmed that and that he just wanted to keep the property for him and his cow. There's a little cow on there.
I see the cow.
Yeah.
Okay, I want to make sure Does the cow have a name?
No, I did not name it yet.
Not yet,
But it's still
okay.
there.
Well, if you only have one cow, that cow should have a name. That's what I think. All right, it looks like a nice piece of property. What's going on?
We bought the property about 2.5 years ago from a neighbor next to us. I own the acre that's right across the street. In January, I contacted a tree company because there was a lot of debris. There were rats. These pine trees, as you can see from the aerial view, there was over 38 pine trees that were 100 foot tall, and whatever. Most of them could hit the house next to it or the house behind. So I went and I contacted Tree Care by Robert Miller, and she came out, and if you want, I can give you this letter. And from what he had told me, that letter was good for the pine trees, but not the oak tree. There's only one oak tree that I know of that's kind of behind me, and you can see it, it's small. There was no way that they could keep that tree with removing those pine trees. And it was more of a safety issue as far as I know, because I know the state of Florida, if a tree on my property falls on the house next door, it's their problem. I'm trying to prevent that, because I know 2 of those trees, if they went, they could have came across the street and hit my house. So I contacted an arborist to have them do what would have to be done.
Any objection on this one?
And then I turned around and I put 5, 10 to 12 foot live oak trees back behind my cow along the fence to try to replace. I'm not a tree hater. I wanted to try to get rid of the danger.
I mean, look, under age-old case law regarding trees, it's true that if you have a dead tree and it falls and it causes damage to a neighbor, you are liable for the damage that's caused. If it's a live tree, then you're not liable. I think Gallo v. Heller, old case here in Florida, speaks to that. But we do have the code section here that is pretty specific. So when did you hire the the arborist?
January 31st, they did the work on February 2nd, they started doing it. And the only reason this came about is if you look at their picture that they have showing up above.
Yeah.
You can see the house to the right of it. That garage, they had a shed on it, and it's on my property. So when I went to the building department to make that complaint, I spoke with a woman, and she said, okay, she didn't do anything for 2 months. I went back there. I said something again to her. She finally went out there, and she says, well, you've removed these without a permit. I said, I didn't know it. I called the tree company.
Right.
Well, then she says, well, maybe you should no, she says, don't get a permit. Just let it go.
Yeah, you got to get a
And
permit.
here I am, so I don't.
Yeah, you definitely have to get a permit. So, Mr. McGuire, when did you start this case?
On June 12th.
Okay. So, when did you get this letter, Mr. Luce?
Which letter?
Your Exhibit C that I introduced as evidence from the tree company.
She gave it to me. She emailed it to me within the past few weeks.
Okay. I ask because it's dated January 30th, so that doesn't seem to be accurate.
Well, because she kept it in with as far as the work goes.
Yeah. It doesn't matter to me. It's just it's useful for the case. Yeah, I mean, certainly the property, it looks better, to be honest, and now you can develop it. I mean, that's part of the problem. That's
Well,
why.
see, it's not being developed.
But that's why the rule, I mean, that's the problem. What's the county's recommendation?
One-time fine of $1,000.
Oh, okay.
I'd rather see it where if let me put spend the extra $1,000 and I'll put 5 more trees on it.
Yeah, well, you should do that regardless, right?
Well, I already did, but.
Is there anyone from the public who wants to be heard on this? This is a new county policy. I've never seen them go below $2,500 in a case like this, so I'll assess the $1,000 fine and wish you luck.
Okay,
Yep.
I'm ready to pay it right now.
All right. Next case?
Next case on the day's agenda, my apologies. Geraldine A. Rose Narrow, case number CE 2026-1000, Code Officer Julie Wilkerson, page 16 of your agenda.
I can't hear, I'm sorry. Can we get something for me to hear with?
Can you hear me? Is she gone permanently? Yeah. Oh, wow. Okay. Well, she was great. She was great.
They're doing a good job figuring it out.
Good. I'm excited. Well, they're paying attention, obviously, so it's, yeah.
I'll just hold it.
Yeah, that might work, but hopefully.
Can we test it now? Can you hear me? Test, test.
Yeah, I can hear you now.
You can hear me?
Just pretty good, not real good.
Do you want me to yell? Do you want me to speak up?
Yes.
Okay. Let's go ahead and swear him in.
Can you hear me?
No, I can't hear you at all. Okay. Yes, I swear to tell the truth no matter what.
Sir, do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right. Very good.
All right.
Let's proceed.
This is case number 2601000, unlicensed inoperable vehicles, a violation of Chapter 20, Article 4, Section 20-41 of the Citrus County Code of Ordinances. The address is 5789 South Happy Drive in Homosassa, Florida. The property owner is Geraldine A. Rose Nero. I have good service via posting the notice of hearing at the property and at the...
One moment, Ms. Wilkinson. Sir, can you hear Ms. Wilkinson?
I'm trying to.
Okay, and what's your name for the record?
Edward Nero.
Okay. Are you a tenant or owner of the property?
I am Geraldine's stepson.
Okay. Is Geraldine alive?
She's alive. She has to have a walker to walk from me to you because she can't.
Okay.
She's bedridden mostly.
Do you live on the property?
Yes, I live
Okay.
in the trailer with her.
Very good. Please proceed. And if you can, try to speak up so he can hear.
Yes, sir. Is this better?
Yeah.
All right. I forgot where I left off, so I'm going to start at the beginning from
yeah.
Exhibit A. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on June 17th, 2026, photos from a corrective action inspection on July 2nd, 2026, and photos from my final inspection conducted on August 18th, 2026. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a photo of the notice of hearing posted at the property, and a copy of the posting affidavit.
Can you tell me a little bit about what's happening on the property before we get into exhibits?
So this is a case, it had a couple of unlicensed vehicles on the property. He covered one of the vehicles with a tarp, thinking that that was going to abate the violation. Once I advised that that was not going to happen, then it became tagged. But there's another truck on the property that remains untagged. However, I have received some information from the stepdaughter, his sister, that vehicle has been sold and will be removed from the property in a matter of days.
That it's in progress, basically, of fixing the violation.
Yes.
Okay. Sir, could I ask you to take a look at these documents and let me know if you have any objection to them being evidence?
Registered it. If you'd like, I can drive it here, but I can't drive because I can't see.
Well, it appears that there's really the county isn't saying you have multiple unlicensed vehicles. The county is saying you only have one left, and it's our understanding that it's about to be fixed. Is that right?
I am the truck that they're talking about. I have nothing to do with it. I don't know. That would be Heather, which is right there.
Well, what I'm saying is, it's up to whoever wants to come speak, you can. Ma'am, I can't. You're not on the microphone. You haven't been sworn in. If you want to come up, I invite you. Ms. Wilkinson, is this the truck that's still from your case that's unlicensed?
Yes.
Okay.
No, you step up, please.
Other hand.
Do Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? I do. If you'll state your name, please.
My name's Heather Nero Mills.
Thank you.
And ma'am, if you could speak in the microphone a little bit.
Heather Nero Mills.
Yes, thank you. And so you're saying that the unlicensed truck has already been removed?
No.
Oh,
My son found out that there was notices and stuff needed to be cleaned up.
yeah.
Okay. As a youngster, obviously you can see, some people are not capable of cleaning things up, and it is a mess there. So him and all his friends started cleaning it up. The vehicle was purchased last week when he found out they needed to be cleaned up.
Good.
So it'll be out by this weekend.
Okay.
It's gone.
Okay.
And I just need to know exactly what needs to be done with that property so I can tell my son what needs to be done.
Well, that's not going to happen today fully. I don't know what else is going on with the property, but this case has to do with unlicensed vehicles.
Yeah, it's gone.
And so to the extent that that will be removed soon, I will give a time to do that. That's reasonable. And if you're saying a week, then I'll give you 2 weeks. You see what I'm saying?
Yeah, go ahead. Because
Now,
like I
there will
said,
be a fine that will accrue if it's not removed in the 2 weeks, but it sounds like
It's gone.
it's going to be gone. Is there anyone from the public who wants to be heard on this? Sir, do you have anything else to say?
Well,
You've been patient.
okay. I don't know what these. See, I was told, okay. So I didn't need to come here?
I don't know. You might be an interested party because maybe you're involved with the vehicles. I don't know why you're here. It's up to you. You don't have to say anything. What I've heard from another witness is that the remaining problem on the property is a problem, but that it will be fixed.
Okay.
So I'm inclined to give 14 days to fix the problem, and if it's not brought into compliance as ordered, a fine of
$150 a day.
$150 a day will start accruing on the property. So someone's got to get rid of that car or get it licensed in the next 14 days.
My car is licensed.
I'm talking about the truck.
Okay, but you said.
So there were multiple
Yeah,
vehicles.
you said car and.
Yeah, there was a
And then
car
you-
problem. That's fixed. That's gone. Not an issue for today. The only issue is the truck.
Okay, she's taking care of that.
You got it.
Okay, so that's it?
That's it.
So I can put my registration back in my car?
Yes, sir.
Thank you.
Thank you.
Have a good day.
And, okay, they're talking about all the stuff that's in the back.
No, I don't know what's going on with that. I'm only here for the vehicles, correct?
Okay,
So I encourage you to contact the county, maybe Ms. Wilkinson, if you have further questions.
okay. Can they send the things to our address instead of the next door neighbors?
The address that my order will go to is the address listed on the property appraiser website. So I don't know what address that is, but if the owner wants to,
next door neighbor.
if the owner wants to change it, then they need to change it with the property appraiser. All right. Thank you, sir.
Thank you.
Next case, Michael J. Clark, case number CE 2026-1088, Code Officer Julie Wilkinson, page 7 of your agenda.
This is a repeat case, a repeat violation initially observed on July 2nd, 2026. The address of the violation is 82 South Lucille Street in Beverly Hills. The case number is CE 2026-01088, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The property owner, Michael J. Clark, has been previously found guilty of the same violation at the same location on May 22nd, 2025. That case number is CE 2025-00269. That case was abated on July 22nd, 2025, with $3,069.98 in imposed fines and administrative costs. I have good service via posting at the property, posting the repeat notice of hearing at the property and the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, the findings of facts, order imposing fine, and order acknowledging compliance from the previous case, CE 2025-00269. Exhibit B, photos taken during an initial inspection on July 2nd, 2026. Photos I took during my subsequent inspections on July 14th, the 21st, the 28th, August 4th, 12th, and the final inspection on August 18th, 2026. Exhibit C, a copy of the repeat notice of violation in a hearing sent to Michael J. Clark, a photo of the notice of violation in hearing posted at the property, a copy of the general pre-hearing order, and a copy of the posting affidavit.
Okay, first of all, is there anyone from the public who wants to be heard on this case? I don't think I see anyone. So we'll admit exhibits A and B as evidence without objection, or A, B, and C, I should say. Let me just quickly take a look at the prior order. Okay. Okay, I'll now take a look at the photos. On the junk scale of 1 to 10, it's on the lower end.
I'd
but
say it's a 0.5.
It's de minimis. I don't know. I'd give you a 1. I mean,
1?
it's there. Yeah. But
Yeah.
tell me what's going on.
So we got a complaint in, and I went out there. I saw it was just some tires. I left a pink door tag, asking, hoping to get that the homeowners would call me back, and they never did. I also called them and left them messages because I had their contact from the previous case. I gave them opportunity to get it fixed before I posted the repeat notice on the property, and I advised them in the
it's obvious that
voicemail.
someone's at the property
Yeah.
because there's kid stuff that's there and then it's not.
Yes.
I guess well, I mean, there's been movement.
There's been movement except for the tires.
Yeah.
But the tires, so they stayed there. I posted the property on July 14th, and the tires remained there until August 4th, and that's when I've considered it to be abated.
Yeah, they're living some kind of dream. Well, you haven't had contact with the owner?
No, and I've called them multiple times and left multiple messages.
What's your recommendation?
$150 a day, along with the administrative costs, to begin on the date of the posting of property, which is July 14th, and to continue until August 4th. That would be 21 days at $150 a day, totaling $3,150.
So ordered.
Thank you.
Next case, James M. Mayer III and Darlene Y. Stuckett, case number CE 2026-1021, Code Officer Robert De Niro, page 11 of your agenda.
There's an old Star Trek episode called Space Seed, and this is where we're introduced to Khan. And when Lieutenant Marla MacGyver first sees Khan, she's like mesmerized. Oh, this guy from the past. And Captain Kirk notices, like, oh, she's hesitating. She's not doing her job quite right. And he calls her out on it, and then she's honest. She just fesses up to it and says, you know what? My reaction was delayed. I'm sorry, Captain. And Captain Kirk said, I'm glad you said that. It's a lot easier to forgive honesty. So it's a recurring theme, I find, in the hearings. Please proceed.
And I'm going to recur a theme of a repeat offense. Robert De Niro, Citrus County Code Compliance Officer. This is a repeat violation initially observed on June 23rd, 2026. The address of the violation is 5566 South Barco Terrace, Inverness, Florida. Case number CE 2026-01021, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-13A of the Citrus County Code of Ordinances. The property owners are James M. Meyer and Darlene Y. Stuckett, had been previously found guilty of the same violation at the same location on April 22nd, 2026, case number 2026-00201 with 0 imposed fines and administrative costs. The case was abated on May 5th, 2026. Good service via posting on the property and the posting of at the Lecanto Government Building. I would like to authenticate the following documents and request they to be admitted into evidence. The findings of facts from the previous case 2026-0021. Exhibit B, photos taken during my initial inspection on June 23rd, 2026, and photos of my subsequent inspections on June 30th, July 7th, July 13th, July 20th, July 27th, August 6th, August 13th, and my final inspection conducted on August 17th, 2026.
Okay. Is there anyone from the public here to speak on the case? I don't see anyone. I'm happy to admit your exhibits if you wish. All right. They are admitted. I would just like to take a moment to look at Exhibit A. I mean, that's fresh.
Yes.
Okay, please proceed.
This property is a single-family residence and is 0.54 acres and is zone low-density residential. I conducted an initial inspection on June 23rd, 2026, and observed tools, tires, trash bags, along with miscellaneous junk and debris throughout the property. I posted a repeat notice of violation and hearing at the property on June 23rd, 2026. I conducted follow-up inspections on June 30th, July 7th, July 13th, 20th, 27th, August 6th, August 13th, and on August 17th, the final inspection was conducted and found that the property had remained in violation. I have had no contact with the owners. Sir, it looks like the owner could be, it's possibly, I think he's in jail. We believe there's a number of squatters that are on the property, and I think we'd like to try to make a valid attempt to try to issue citation summonses to them if you grant us that opportunity to do so.
Well, if that is the case, how did it get cleaned up last time? I mean, do you think they just moved it to another place and then brought it back?
I don't know when I should have done a little bit more research, to be quite honest with you, but I don't know when the person was incarcerated and if in fact he and his wife, or his partner I should say, had cleaned up the property or previous, because it was abated.
I see. So you think it may be a function of the owners just not being there and then squatters?
It seems that's what's taking place in the neighborhood. That's some of the initial information we're receiving from some of the people that live on the block.
Have you checked the county jail records or anything?
No, not at this time. I have not.
I mean, what do you want me to do?
At the moment, I'm requesting a fine of $250 a day along with the administrative cost, and from my initial inspection until August 16, 2026, that's 56 days at $250 a day, totaling $14,000.
And going forward, I mean,
$250 a day from this day forward if the violation is not abated.
but you know, they abated the violation before, and you think that they may not even be the main reason.
I believe one of the two parties may not be there. I didn't say that the other party wasn't there. I'm not, I've had no contact with the owners.
Okay, I'll so order it at $250 a day for the 56 days prior and $250 going forward until abated.
Thank you, sir.
Thank you.
Next case, RBM Financial Group, LLC, case number CE 2026-1030, Code Officer Robert DeNaro, page 15 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Thank you. Robert DeNaro, Citrus County Code Compliance Officer, case number 2026-0130, a violation of Citrus County Land Development Code Section 4002, site development without development order or permit. The address is 6122 East Holly Street, Inverness, Florida. Property owner, RBM Financial Group. Good service via posting of the notice of violation / hearing at the property in the Lecanto Government Building. I would like to authenticate the following documents and request them to be admitted in evidence. Photos that were taken on my initial inspection on June 26, 2026, along with the aerial photos of from the Citrus County property appraiser dated July 12th, 2025. Exhibit B, a copy of the notice violation hearing, a copy of the notice of general pre-order, a photo of the notice of hearing posted at the property, and a copy of the posting affidavit.
Okay.
This property is listed as a vacant lot, 0.22 acres, and is zoned medium density and residential. I've conducted an initial inspection on June 26, 2026, and observed a once wooded lot that had been clear cut. While researching the property, permits were issued on April 23rd, 2026, and as of that date, applied for, on April 23rd, 2026, and as of this date have not been issued. I've had no contact with the owner, and my expert on this case is Land Development Director Joanna Coutu.
Sorry, it's about 0.22 acres. They did apply on April 23rd. They were denied on April 30th by both building and engineering, and there's been no contact since that time.
Have you had any other interactions with this, like RBM Financial Group? Have they applied for other permits and done work within the county?
I'm not familiar with them. The contractor in the case is CF Development Solutions out of Winter Garden, also one I'm not familiar with.
Thank you. Is there anyone from the public? Nope. What's the county's recommendation?
I respectfully request a one-time fine of $5,000 along with the administrative costs.
Can I see the exhibits?
Yes, sir.
They're admitted as evidence. Thank you. Okay, the fine is so ordered.
Thank you.
Thanks.
Last case, Matthew Alexander Thomas and Kayla Jean Galesso, case number CE 2026-1053, Code Officer Robert DeNaro, page 18 of your agenda.
Thank you. Robert DeNaro, Citrus County Code Compliance Officer, case number CE 2026-00018, excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20-61 of the Citrus County Code of Ordinances. The address is 10509 East Joy Lane, Inverness, Florida. The owners are Matthew Alexander Thomas, Kayla Jean Galasco. Good service posting of the notice of posted at the property and of the posting at the Lecanto Government Building. I would like to authenticate the following documents and request them to be admitted into evidence. Exhibit A, photos taken on my initial inspection on June 25th, 2026. Corrective action inspection conducted on July 10th, 2026. Photos of my final inspection conducted on August 17th, 2026. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the notice of the general pre-hearing order, a copy of the posting affidavit, and the photo of the notice of hearing posted on the property.
Okay,
Okay.
I'd like to take a look at the exhibits
Okay.
if you have them. Exhibits A and B are admitted without objection. This is a classic overgrown, unkempt lawn case. Go ahead.
On, excuse me, on June 25th, 2026, I conducted an initial inspection and observed the property being in violation, and a notice of violation was issued for excessive growth and the accumulation of vegetation. On July 10th, 2026, a corrective action inspection was conducted, and I observed that the property had remained in violation. As of my final inspection on August 17th, 2026, the property remains in violation. I have had no contact with the owners.
Yeah, I mean, in terms of overgrown lawn on the Becker scale, this is probably 4. I'd say it's a 4. Or 5. So what's your recommendation?
$50 a day.
$50 a day. Did you say you'd had contact with the owner?
I had no contact with the
Okay.
owner, sir.
Okay, 10 days, $100 a day.
Thank you, sir.
Is that the last case?
Yes, sir.
Is there anything else that the county wants to take up before we adjourn?
I don't have anything, no, sir.
Okay, I don't think I have anything either, except that I for sure will not be here in October.
Yes, sir.
Now, pending whatever happens, babies can come early, so I just be on call for if something happens, and I may have to bow out. All right, the time is 11:17. This hearing is adjourned.